When it comes to putting off or refusing to create an estate plan, your mind can concoct all sorts of rationalizations. I won't care because I'll be dead. I'm too young. That won't happen to me. My family will know what to do, or I can't afford it. But these thoughts all come from a mix of pride, denial, and above all, a real lack of education about estate planning and the consequences to your family of not planning. Once you understand exactly how planning is designed to work and what it protects against, you'll realize that there is no acceptable excuse for not having a plan. My name is Sotera Anderson, and I protect families and their legacies by helping them plan for the unexpected. The first step in creating a proper plan is to thoroughly understand the potential consequences of going without one. In the event of your death or incapacity, not having a plan could be incredibly traumatic and costly for both you and your family, who will be forced to deal with the mess that you've left behind. While each estate and family are unique, here are some of the things that most likely will happen to you and your loved ones if you fail to create a plan. 1, your family will have to go to court if you don't have a plan, or if you only have a will. So yes, even with the will, you are forcing your family to go through probate upon your death. And probate is the legal process for settling your estate. And even if you have a will, it's notoriously slow, costly, and public. But without a plan, probate can be a nightmare for your loved ones. Depending on the complexity of your estate, it can take months or even years to complete. And like most court proceedings, probate can be expensive. And in fact, once all your debts and taxes and court fees have been paid, there might be nothing left for anyone to inherit. And if there are assets left, your family will likely have to pay a hefty attorney's fees for court costs in order to claim them. Yet the most burdensome part of probate is the frustration and anxiety that you are going to cause your loved ones. In addition to grieving your death and planning for your funeral and contacting everyone you're close with, your family will be stuck dealing with a crowded court system that can be challenging to navigate, even in the best of circumstances. Plus, the entire affair is open to the public, which can make things all the more arduous and for those that you leave behind, especially if wrong people take an interest in your family's affairs. But that said, the expense and drama of the court system can be almost totally avoided if you plan properly. Using a trust, for example, we can ensure that your assets are passed directly to your family upon your death without the need of any court intervention. As long as you have planned properly, just about everything can happen in the privacy of our office and your family's and on your family's time. Number 2, you have no control over who inherits your assets if you die without a plan. The court will decide who inherits your assets, and this can lead to all sorts of problems. Who is entitled to your property is determined by our state's interstate succession laws, which hinge largely upon whether you are married and if you have children. Spouses and children are given top priority, followed by other closest living family members. And if you're single with no children, your assets typically will go to your parents or your siblings, and then more distant relatives if you don't have living parents or siblings. And if there's no living relatives can be located, then your assets are going to go to the state. But you can change all of this with a plan and ensure that your assets pass the way that you want without going through the court system. And so it's important to note that state laws only apply to blood relatives. So unmarried partners or close friends, they won't get anything if you wanted them to. Or if you want someone outside of your family to inherit your property, having a plan is an absolute must. If you are married with children and you die without a plan, it may seem like things would go fairly smoothly, but that's not always the case. If you're married but have children from a previous marriage, for example, or a previous relationship, the court could give everything to your spouse and leave your children out. In another instance, you might be estranged from your kids and or you don't trust them with money, and without a plan, state law is really going to control who gets your assets and not you. So dying without a plan could also cause your surviving family members to get into an ugly court battle over who has the most right to your property. Or even if you become incapacitated, your loved ones could even get into conflict over your medical care. You may think that this isn't going to happen with your loved ones, but we see families torn apart all the time. And when there's little financial wealth involved, we can help you create a plan that handles your assets and your care in the exact manner that you want, taking into account all of your family dynamics, so your death or incapacity won't be more painful or more expensive for your family than it really needs to be. And then number 3, you have no control over your medical, financial, or legal decisions in the event of your incapacity. And most people assume that estate planning, it really only comes into play when you die, but that is dead wrong. Pun fully intended. So although planning for your eventual death is a big part of the process, it's just as important, if not more so, to plan for your potential incapacity or accident or illness. If you become incapacitated and you have no plan in place, your family would have to petition a court to appoint a guardian or a conservator to manage your affairs. And this process can be extremely costly, time-consuming, and traumatic for everyone involved. In fact, incapacity can be a much greater burden on your loved ones than your death might be. So me, as your personal legacy lawyer, I can help you put planning vehicles in place that grant people the choice for your immediate authority to take your medical, financial, and legal decisions for you in the event that you become incapacitated. We can also implement planning strategies that provide specific guidelines detailing how you want your medical care to be managed, including critical end-of-life decisions. And then number 4, you have no control over who will raise your children. If you're a parent of minor children, the most devastating consequence of not having an estate plan is what could happen to your kids in the event of your death or incapacity. Without a plan in place, naming legal guardians for your kids, it will be left to a judge to decide who should care for your kids. And this could be major heartbreak, not only for your children, but for your entire family. You'd like to think that a judge would select the best person to care for your kids, but it doesn't always work out that way. The judge could pick someone from your family that you never would have wanted them to raise your kids to adulthood. And if you don't have any family, or the family you do have is deemed unfit, your children could be raised by total strangers. What's more is, if you have several relatives who want to care for your kids, they could end up fighting one another in court over who gets custody. And this can get extremely ugly. And, otherwise well-meaning family members fighting over your kids for years, making their lawyers wealthy, but your kids are stuck in the middle. It's stuff like this, with this in mind, that if you have minor kids, your number one priority for planning should be naming legal guardians to care for your kids if anything happens to you. I can't tell you how critical this is, and we have developed a comprehensive system called the Kids Protection Plan that will guide you step by step through the process of creating the legal documents you need to name the guardians. And naming legal guardians won't keep your family out of court, as a judge is always required to finalize the legal naming of guardians in the event of your death or incapacity of parents. But if it's important to you to who raises your kids, if you can't, you need to give a judge clear direction. And then on top of that, you need to take action to keep your kids out of the care of strangers over the immediate term while the authorities are trying to figure out what to do if you're incapacitated or dead. And we handle all of that in our kids protection plan too. You can get this process started right now for free by visiting our user-friendly website, personallegacylawyer.kidsprotectionplan.com. No more excuses. Given the potential dire consequences for both you and your family, you can't afford to put off creating your estate plan any longer. I'm your personal legacy lawyer, and I will guide you step by step through the planning process to ensure that you've taken all the proper precautions to spare your loved ones from needless frustration, conflict, and expense. All that said, the biggest benefit you stand to gain from putting a plan in place is really the peace of mind that comes from knowing that your loved ones will be provided for and cared for no matter what happens to you. So don't wait another day. Contact us, your personal legacy lawyer, to schedule an appointment so you can finally check this urgent task off of your to-do list. I look forward to speaking with you and helping you. Take care.